We are so excited to launch our first business webinar in a series. And it's so exciting to just watch. I think there's 321 of you logged on so far. So the response has been overwhelming, and we're grateful that you're going to spend this hour with us. I spent the last year and a half sort of traveling all over the state to our 24 local offices, and we heard everywhere we went, in every business roundtable, that businesses need sort of digestible information about things going on it related to our department, in a way that they can access when they want, and that is easy to understand given all the million competing things that business owners and HR professionals do every day. And so that's why we started this webinar series. And immigration is an area where we've just seen so many changes over the past few months, at the federal level. It's something that we don't have a lot of insight to as everyday New Mexicans, but we know that in New Mexico, immigrants are such a critical part of our economy, both as employers and as workers. We have about 130,000 immigrant workers. Roughly 13% of the workers in the labor force in New Mexico are immigrant workers, and 15,600 immigrant entrepreneurs, so almost 17% of business owners. So they're just such an important part of the fabric of our state, and especially in industries like construction, where immigrant workers represent 23% of the labor force, and agriculture, forestry, fishing, 20%. I won't bore you with a lot of numbers, but I think we all know that immigration issues really hit home here in New Mexico. And that's really why we started the Office of New Americans. This is an office to especially deal with all the issues sort of at the intersection of work and immigration. And when we started this last year, we had no idea quite how important this office was going to be, but we were very fortunate to get an expert in this area, Leo Castañeda, who joined us and will be part of this presentation today, and who recruited, and we're so grateful for Olsi Vrapi, an attorney here who works in immigration law. I know I'm going to be taking notes because I don't know any of the stuff they know. I'm grateful to them for sharing their expertise, and I'll turn it over. Thank you.
Thank you so much, Secretary. And I will ask Olsi if he can share with us a few thoughts, and before we get into some of the questions from the audience and some questions we have, we'd love to hear what you think people should know. First of all, like what are the biggest concerns and biggest questions that employers need to be thinking about with immigration? It's such a rapidly changing field, and maybe we can go to the next slide and just very quickly, like Stacy said, please put your questions at the bottom, and we're going to have a bit of a conversation. And yeah, I'll take it away. What should folks know?
Thank you for having me and inviting me to the webinar. I am pleased to be here. My name is Olsi Vrapi, and I practice immigration law here in New Mexico. We have offices in Albuquerque and Santa Fe, and we do about half of our practice is actually dedicated to working with employers in employment-based immigration issues, obtaining visas, and advising employers and how to leverage foreign talent, essentially. So I'm sure I've looked at the list of folks briefly, and I recognize some names in there that are the participants. So I'm glad we're having this conversation. So the biggest question that we're facing right now is just uncertainty and fear because of not knowing what to expect tomorrow, and not knowing how to make business decisions that sometimes you have to be able to look in a year, 2, 3, 5 years ahead of time. But something can change at a drop of a hat tomorrow that can thwart those plans, right? And I wish I had answers. I wish I had a crystal ball to tell you exactly what's going to happen and be able to answer all those questions, but we can't. And so, sort of like we go back to that maxim of we try to control the things that we can right now and not have to worry about the things that we can't control, right? And so we handle things as they exist today and not have to worry about it too much until tomorrow. Let's worry about something when there's something to worry about, right? So for the time being, there are some things that sort of like the administration has signaled that they plan on ramping up enforcement in certain areas. And so we know some things that are in the landscape that are about to come down the pike. But for others, we just kind of take it day by day and see what happens. The things that have been signaled out have been things like probably a ramp up of I-9 enforcement. We might be seeing more I-9 audits. Historically, even during big pushes, it's just the issue of resources. The local HSI office probably can only do about 20, 30 I-9 audits a year. And so that's drop in the bucket, so to speak, compared to the number of employers that are in the state. But even then, it could be somewhat, unsettling to have to go through one of those. And so, our proactive, our advice to clients to be proactive about it is to sort of like do a self audit and just go through your I-9s and make sure that everything, all the T's are crossed and all the I's are dotted, so that in event of an audit, you can easily turn that around and pass it successfully. The other big issue that has come up has been with workers that have quasi status or precarious types of statuses. So like DACA, parolees, and I'm sure we're going to delve into some of those topics a bit more in depth today, but just to kind of hit the highlights. DACA, parolees, and some of these programs that are what I call president made. One president says, I'm going to create this one program as a matter of policy, but that means that the next president can take that away at the stroke of a pen as well, right? But then not so worried about things that are statutory, like H-1B visas and F-1 and J-1 visas and those kinds of things that are harder to change and harder to take away because it requires an act of Congress to change such things. So those are sort of like the big topics that we're seeing, from employers, that is. And then from employees, from foreign national employees, we're seeing a lot of confusion about the alien registration requirement that was recently announced that went into effect on April 11th. And just the general, like, hey, what's my future? If I have DACA or if I have parole, what am I gonna, am I gonna have a job in 6 months, right? So those are some of the things that we're fielding today, and we've been able to help folks. But Leo, I'll turn it back to you, because I know there's some points of discussion that we need to go over and answer some questions as well.
Yeah, no, thank you. I think that's super helpful. And like you said, we're gonna circle back on some of those specific points a little bit more. And I know we're already getting some questions in the chat and in the Q&A. And just want to remind folks, this is not an attorney-client conversation. This does not establish privilege. It's not solicitation, and it's not legal advice or a substitute for legal advice, but we want to make sure that folks have at least some broad outlines of what they need to be thinking about and next steps that they have to be taking. So let me ask you, because I know we're going to talk a lot about folks who are already in the country or who have some sort of status independent of their employment that gives them work authorization, like you said, DACA, parolees, temporary protective status. And we're going to talk a lot about those, but let's talk a little bit about the H's and the employment-based visas. If there are employers who are looking at employees with technical skills that they need to bring in, and they're looking at, or in agriculture, we have H-1B, H-2A, is that something that employers should still consider an option? Should they still be thinking about doing recruitment for that, or is that something that you're hearing or seeing changes down the pike that make that a less viable option for those specialized workers?
Very good question. I don't see any or foresee any changes in the H-1B program. Nothing has changed so far in it. It's still the same. The H-1B program is largely statutory, and so it's not very easy to mess with. There was an attempt by the first Trump administration to sort of like tweak the prevailing wages that are required for H-1Bs, because to get an H-1B visa or to petition for somebody for permanent residence, an employer must show that they are paying prevailing wage, which is determined by the Department of Labor. There's statistical studies that the Department of Labor does. And so there was an effort to increase those substantially, but that got snagged in litigation for a variety of reasons. We don't know if that's going to come back up again, but short of something like that, there's not much that can happen to the H-1B program to alter it in any meaningful way. So that's a program that a lot of employers rely on. And especially now in the last 2 or 3 years, as the labor market has been fairly tight, even employers that didn't consider foreign workers before, not having to deal with the H-1B process and all that, are now setting policies in place for their recruitment teams to be able to recruit for those workers because they've become a necessary part of the labor of the workforce. And so I don't expect any problems. Everything is business as usual in that arena so far.
And just for us remedial listeners like myself, can you just, in a couple sentences, describe what the H-1B visa is?
Yes. So there are a number of non-immigrant visas, meaning that folks can come into the United States for a particular purpose for a fixed duration of time. H-1Bs are one of these types of visas, and they are reserved for what they call specialty occupations, meaning that jobs that require professional positions, jobs that require a bachelor's degree or higher as sort of like the norm, right? So engineers, accountants, lawyers, teachers, what have you. There are other types of visas, such as the H-2A for agricultural workers, H-2B for seasonal workers, like folks that work at the ski resorts or the summer resorts, things like that. But the H-1B is sort of like the most common one because of all the professional occupations. There are, and this is a question that I get a lot actually, so even though it goes a bit beyond the call of the question, I think it's worth mentioning, is that there is no generic work visa that one can get for foreign national employees unless it falls under one of these niches. So if somebody has a construction company and says, I've got 10 framers in Mexico that I can hire tomorrow, and these are really good workers that I would use in my business, there is no non-immigrant option for those workers to come into the US. So for anything that's outside of agricultural work or seasonal work that we talked about, there's special visas for those, or this professional, so like anything less than the bachelor's degree requirement, there's not really any options for folks to bring in talent on non-immigrant visas.
Hey, thank you so much. Yeah, I think that's very important. Someone flagged in the Q&A, the last time there was a moratorium on premium processing, which again is an additional fee that folks can pay for expedited processing if you're operating under a cap. So the limit for the number of H-1Bs, it doesn't speed up how quickly your employee could start, but for those kind of nonprofit and research organizations, that did create an additional
Yeah.
flow that.
Yeah, and one additional comment to what Leo was saying is that H-1Bs, for however good they are limited in number. They only give out, the federal government has only allotted 85,000 visas for the entire country for a full year. And the problem with that is that there's a lot more demand than there are visas available. And there's a lottery in place that they enter every year because they get 500,000 registrations for those 85,000 visas. However, a lot of employers are exempt from that cap, and a lot of them don't even know it. A lot of my consultations, I tell them like, yeah, you can get an H-1B tomorrow. Like, we don't have to enter the lottery. Oh, no, you don't. And here's the reason why. So the two most common exemptions, or three most common exemptions, are first, institutions of higher education. So universities, community colleges, all of those. Not the for-profit ones, but like the ones that fit the definition of institution of higher education in federal law are exempt. They can file H-1Bs whenever they want to, no limitation. But also nonprofits that are affiliated with an institution of higher education are also exempt. For example, New Mexico Department of Workforce Solutions could be cap exempt because a lot of times governmental entities are, well, first of all, they're nonprofit by nature of being a governmental entity. But second, almost always they have some sort of collaboration with one of our universities in the state for either research projects, data sharing, intern training, training programs, a variety of different things. And those are sufficient affiliations so that governmental entities can actually petition for H-1Bs whenever they want to. Municipalities, public schools, charter schools. So a lot of nonprofit industry can actually become CAP exempt under certain conditions. And so, which creates a lot of, opportunities to fill in labor shortages.
Great, thank you. Yeah, and go ahead.
Oh, sorry. I was just going to say, I think this is a good lead into a question for Secretary Nair. And that is, what programs are there if I'm losing skilled workers in industries like construction for me to recruit new workers or develop those workers?
Yeah, so thanks, Stacy, and whoever asked the question. We of course have a labor shortage overall in New Mexico, partly due to the fact that we have one of the lowest labor force participation rates in the country, which is the number of people who are of the age to work, but are not working. So we feel like there's a real bench, or even maybe not quite at the bench, but a lot of folks who are in the stands who are not in the labor market yet, but who might have skills and interests that match with businesses, or might have the desire to get back into the workforce, but don't know how. So we've really focused on those types of programs to help those folks, and that also ends up helping employers directly over the past few years. So pre-apprenticeship is one of those programs where we're trying to get youth 16 to 24, but I think our oldest pre-apprentice was 50. These are folks who need a period of subsidized wages to be able to enter the workforce and really be able to work for an employer full time, or maybe need a little bit of training. Of course, the Workforce Innovation and Opportunity Act also provides for both on-the-job training and some education funding. And then apprenticeship is another great tool. We see about a 90% retention rate of people who start with an apprenticeship at a company. They build that loyalty over time, and by the time they're a journey worker, they want to stay with that employer. So there's a lot of loyalty built up that way. We also have a number of recruiting services. So Stacy and her team who brought us this webinar can help with videos and getting personal testimonials of why to work for your company. And then of course we do rapid hires all over the state, as well as just the simple act of posting a job with our job board. So just encourage everyone out there, if you are struggling with workers, and if some of the immigration changes have made that struggle more acute, come into your local America's Job Center or contact us here at the Department of Workforce Solutions, and let's try to work together. Thanks.
Thank you. I'm going to ask another one of the audience questions, and I think folks want to know a little bit more about the registration requirement, the alien registration requirement. That applies across the board, and I know for folks who have H status, and we'll focus a little bit on those folks who have some employment visa, green card holders. I know the advice has been to have lawful permanent residents to have their green card with them, but what documentation would you recommend that folks who have workers on other types of visas, other types of status have with them in order to meet that, prove that they meet the registration requirements?
Yeah, good question. So there are actually 3 separate requirements, or 3 separate continuing obligations. And the registration requirement that was just announced is only one of them. So the registration requirement is not something new, actually. It's a law that's been in the books for about 50 years. It's just that this one is being weaponized and sort of like taken, a few notches above where it should be. And the registration requirement, many folks are not required to register because they are already registered. So anybody who is a permanent resident over age 14 is already registered. Anybody who is here on any sort of visa, like HL, any kind of visa, even students, F visas, are already registered. So if somebody has been admitted to the country and issued what is called an I-94 document, which is a document of admission, that person is already registered, does not need to do this new registration process. Anybody who's ever been issued a visa, so even visitors from Mexico that just have the border crosser card, it's called, or a visa láser, even having used that without obtaining an I-94, even that one is evidence of registration. And the I-94s are electronic most of the time these days. And so you just print one out from the CBP website and you carry that with you. Permanent residents are supposed to carry their green cards with them all the time. So again, there's 3 separate requirements. One is to register. Number 2 is to carry proof of registration that we were talking about, carry the green card, carry the I-94. And number 3 is changes of address. Everybody, including permanent residents, is required to, by law, notify USCIS of their change of address within 10 days of moving. And even if you add a second address, like get a second home, you're supposed to notify that as well. And so all those are continuing obligations, and all those have criminal penalties if one fails to follow those.
Great, thank you. So I think important for folks to keep all that information in mind and make sure what questions, what documentation they need to have with them. And I think that's an important support for
Right.
employers to make sure that their employees are keeping. Let Stacy see if she has another question that she wants to ask for the audience.
Thank you. So the next question is, what should employers do if they receive a notice of an audit? Oh, I'm so sorry. Let's choose this one. I apologize. What do I do if I had a work authorized employee that suddenly had their status and authorization revoked and either left the country or was detained?
Yeah, I can take that one and then see if you want to add, but I think, the important thing to remember in those cases is that state labor law still applies. So hours worked, PTO earned, that is still owed to that employee. And, it can be a little tricky if that employee is no longer accessible or in the country, but it's important for folks to make sure that they're still meeting all the requirements, regardless of what the status might have been of the employee, that all those wages are still being paid out under existing state law, which is not affected by federal changes. Does that sound right? See?
Yeah, the federal requirement is only as to hiring somebody, meaning that a worker needs to be authorized to be employed. But in terms of like pay and benefits, state law is what controls. And so even if federal law, for example, says, let's say an employee goes and gives an employer actual knowledge and says, hey, my documents are fake, I'm here unlawfully, whatever. Federal law obligates the employer to terminate the employee, but up until the point of termination, the employer is still liable for wages and benefits and time off and all of the things that Leo mentioned.
Great, thank you. And I think that answers a couple other questions in the chat. I'm gonna lob you an easier one, which is what happens if you have an employee with an expired green card? And my understanding, and correct me, is the status does not expire, but the cards do have to be renewed every 10 years. So would that advice then be for that individual to sort of renew their card as soon as possible and make sure that all the information is up to
From an employer's perspective, the general rule for permanent residents is, as you said, that permanent residence is permanent. The status does not expire. The card itself is only proof of the permanent status. It's not the actual status. So if the card expires, then the status doesn't necessarily expire. There's a couple of small exceptions to this, but by and large, if somebody has an expired green card and they were I-9 verified before the expiration of the card, the employer should not re-verify that person even if they have a new card. In other words, expired green cards do not have to be re-verified. There are certain small exceptions to that for conditional permanent residence and things like that, but by and large, the employer carries no obligation, not even to give as a best practice to say, hey, you should renew this or whatever, because going above and beyond the requirements of the I-9 could be seen as discrimination.
Great. I think that's a very important point is, employers should not be sort of trying to play detective and after the fact, post-employment or during employment, try to identify individuals and go backwards and try to identify individuals in a way that could be run counter to state law. We have a question here. I'll lob you another good one. Difference between green card and naturalized citizen. And I think this is a good kind of lay down, and maybe you can give us a little bit about sort of how long folks have to wait within their green card in order to apply for naturalization. And that might be good advice for folks to consider right now.
Yeah, so Naturalized citizen means somebody is a U.S. citizen, just like anybody who was born in the United States, with all the rights and responsibilities of citizens. And that means that even if they commit a crime or whatever after they're naturalized, they cannot be deported from the country. On the other hand, permanent residence is they remain a citizen of their home country. They are not United States citizens, but they are allowed to permanently reside in the United States and work for any employer without any sort of restrictions. So permanent residence, on the other hand, can be lost. If somebody goes and commits certain types of crimes, they can be deported from the country. You can be deported for even lesser things than crimes. So there's a long list of things that can get somebody deported. But it's sort of like, yes, permanent, you can live here, but you may lose that status at some point. A permanent resident status can also be lost by abandonment. If you go spend too much time abroad, you may lose that status, right? Now, for permanent residents who want to become U.S. citizens, the general rule is that you have to be a permanent resident for 5 years to become a naturalized U.S. citizen. If the permanent resident is married to and living with, in marital union with a United States citizen, that requirement is cut down from 5 years to 3 years. So, and you can file actually 90 days before the 5 years and the 3 years. So technically 4 years and 9 months and 2 years and 9 months to apply for citizenship in those respective cases. There are some other very rare circumstances where like spouses of military who are about to be deployed don't even have to comply with that 3 or 5 year requirement. They can apply for naturalization the day they become a permanent resident. So there's some small exceptions, but by and large, it's either 5 or 3 years.
Great, thank you. Yeah, I think that's really helpful and good reminder for folks. I think there's about 30,000 New Mexican residents who are eligible for naturalization, and probably a good idea to launch that process.
Yes.
We're getting a couple more questions on I-9. So maybe I can ask you, and we're gonna, when we send out the recording for this, we'll share some additional resources. So this doesn't need to be exhaustive, and obviously every case, there's always going to be a little variability, but maybe you can walk us through a broad strokes, what an I-9 audit looks like and what information folks will be asked to provide.
Right. So typically an I-9 audit starts with officers from the Homeland Security Investigations branch of DHS, which is sort of like ICE, but not ICE, shows up at a business with what is called a notice of inspection. And the notice of inspection gives the business 72 hours to turn over I-9 records. And typically it has other requirements in there, like you have to give us a roster of all the employees, not just current employees, but even employees that have been terminated within a certain amount of time, because there's a retention requirement for I-9s as well. And then all the I-9s that are either for current employees or within the retention period with supporting documentation if the employer retains the supporting documentation for the I-9s. And a quick tip here to the employers is if you still do I-9s on paper, my recommendation is to not retain the supporting documents. So like if an employee shows up with let's say a copy of their green card, for example, their green card to do I-9 verification, it's not a good idea to retain a copy of that card. It is not required that you retain copies, and it's a best practice not to retain a copy of it. But you have to do that for everybody. You can't just be like, for these folks, I'm going to keep copies. For these other folks, I'm not. So you have to do that for everybody. But if you can change the policy and not retain copies for the future, because a lot of times in an audit, you turn those documents over. Immigration officials will check those documents. So in an I-9 audit, the I-9 responsibility of the employer is sort of like a razor's edge that employers have to walk. And the reason for that is this. The I-9 was born out of the 1986 Reagan amnesty, and it essentially deputizes all employers to do the federal government's bidding, where the employer is supposed to sort of like enforce immigration law, right, to make sure that somebody's authorized to be employed. So on the one hand, you have HSI that if you don't do that properly, if you hire somebody who is unauthorized, doesn't have the right documents, you can be fined or even criminally prosecuted by HSI for hiring unauthorized workers. On the other hand, if you do too good a job and you play investigator, like Leo was saying earlier, or you try to go a bit above and beyond and take more documents than you're supposed to, then you are liable for discrimination to the Department of Justice. And so it's this really fine line that we have to walk as employers. On the one hand, trying to do our duty, but then not go too far beyond, because then you can get in trouble with a different government agency. So for the part of the employer, all the employer has to do and verify is that the documents are facially valid. You're not supposed to be a forensic expert to know, like, this document needs to look this way or that way. There's a guide on the USCIS website that tells you what the documents are supposed to look like. If it looks like that, that's the end of it, right? And so even if the documents turn out to be fake down the road, you don't have any liability if you did the process properly, right? Now, the reason why it's a good idea not to retain copies of the documents is because then it gives HSI sort of like a bone to pick and be like, well, you should have known this document is fake. It looks really bad. You're like, how the heck should I know? I'm not an immigration lawyer. I don't do this for a living. It looks like that one. It looked good enough to me, right? But when there's no document or to sort of like to forensically examine like a copy of it, then it's less opportunity for HSI to pick bones with employers. They will still check it. They'll run the number that you put on the I-9 form and all that stuff, and they'll determine whether it's valid or not. But at the very least, it's not going to be like this added burden on the employer to sort of, like be liable because you should have known better, right? Because
Right.
I know I could take a fake document, but I look at those every day. Anybody else, really hard to tell.
Right. No, I think that's important. And, sometimes these documents change. I know, some of the I-797, which is one of the forms that folks receive if they have
Right.
a visa holder,
They
those
change
forms.
all the time. Yes, they look very
Right.
different.
Yeah. So I think that's important. And getting some follow-up questions, and I think people really appreciated your run through. It sounds like that's across the board, that documentation, right? Social security numbers, green cards, whatever work authorization, that doesn't need to be retained after the employer has sort of verified that it looks correct.
Correct. The only requirement is that you write the information down on the I-9 form under Section 2 for whatever the form is asking about. You are not required to retain a copy of the document that was presented to you. The other reason is because sometimes folks, HR folks don't know, and if an employee shows up with too many documents, let's say they show up with their green card and their social security card, I-9s require either one document from list A or a document from list B plus a document from list C. The green card is a list A document. The social security card is a list C document. So if you take both of those and make copies of those, that is considered over documentation, and it's a violation of the I-9 rules. So even if you just wrote the green card information in the Form I-9, just keeping a copy of the social, because, hey, they brought it, might as well, right? Like it's a best practice to keep copies of things in general. It's not in the I-9 world. So I've seen a lot of employers get burned for that because somebody was just trying to do a good job and over documented something when they shouldn't have.
Right. That's great. That's really helpful information. Thank you. Seeing a couple questions, what should folks do? Is there broad guidance for folks who have been keeping a lot of documentation? You talked about, you can change that policy as long as that policy is consistent across the board. Can folks change their policy going backwards and say, across the board, I'm just going to retain the I-9 with the, writing down all the information that I need to keep, and I'm going to dispose of any additional documentation? Is that something that folks can do, or would you say keep what you've kept up to now, but you can change only going forward?
It's the last thing you said. You cannot go back and purge documents that are still within the retention period, even if you change your policy now. What's done is done, and it stays there. But going forward, you can change the policy to not retain documents or copies, that is, and so forth, but only prospectively. Even when you do an I-9 audit and you find errors on the I-9s, there are special procedures in which you correct things. You have to initial and date things, and you have to cross out, no whiteouts, nothing like that, right? So like it's a very technical process, and you have to follow certain rules to not get into trouble with HSI saying, oh, you're, tampering with evidence or whatever, right?
Yeah, great. That makes sense. And I think some folks still have, very detailed questions, so maybe we'll get to some more specifics, but I do want to talk about some of the broader other settings or other statuses that folks can have. See some questions on healthcare workers and things like J1 visas.
Right.
So to give some context, J visas are cultural exchange visas. We see them used for teachers, au pairs, temporary workers, as well as folks doing residency or even other medical programs.
Physicians,
So
yeah.
physicians, etc. Can you give us a little bit about, can you talk a little bit about who and how the 2-year rule works? Essentially, the requirement that folks upon completion of their program that they got for their J visa
Yes.
go back. I think that's sometimes a concern that people have is they get sort of to the end of their current J visa period and they say, I love this person. I really want to bring them on as an H-1B
Yeah.
worker, keep them on.
Yeah.
Is there, are there pathways to do that?
Yes. So that's actually my bread and butter, because a lot of my so there's 6 attorneys in our firm, and we do a variety of different things in the employment-based immigration world. But my personal sort of like brunt of my work and my specialty is healthcare. So a lot of my clients are medical practices and hospitals and physicians. And the J1 visa, like you said, is a very versatile visa. It's for exchange programs, anywhere from you froze there, Leo. Is that me or is that you?
I think it's you. We can
It's
still hear
me.
you though.
I'm back.
There
I'm
you go.
back.
You're
Great.
back.
All right. I just want to make sure I wasn't talking to a blank screen. And I think I'm out again.
We can still hear you, so I think you're fine.
If you all can hear me, I'll still continue talking, I guess.
Yeah.
Oh my gosh, internet connection unstable. Let me see if I can join through my phone, maybe better. Can you see me and hear me now
We can
better?
hear you. Yeah, you're back.
Okay, great. So, the J1 program is very versatile. It could be from nannies to brain surgeons coming and doing medical training in the US, right? And anybody in between. The 2 most common types that we see in New Mexico, or 3 most, are either researchers like postdocs that do research at the universities in New Mexico or the national labs. And then the second type is physicians who come for medical training in the US. And then the third one is teachers. There's a lot of teachers that come and do cultural exchange in the US as well. Now, some of these J1 visa holders are subject to what is called a 2-year home residency requirement, because the idea of cultural exchange is you come here, we exchange, and then you go back to your country for 2 years before you can get an H-1B visa, an L visa, or permanent residence. This is sort of like the US's imperialistic thinking, like, bring us your people, we will educate them with our American values, and we will force them to go back to make your countries better like ours, right? So it's a bit conceited, but it is what it is. That's the law that's been there for decades, right? So the folks are subject to the 2-year home residency requirement under one of 3 conditions. One is if they came to do graduate medical training in the US. So any physicians who are coming in the US in J1 to do residency or fellowships are automatically subject to the 2-year rule. Number 2 is if the program was funded by either US government or home government funding. And that means US government funding exchanged or earmarked for exchange programs like Fulbright program, things like that. For example, if University of New Mexico sponsors somebody, those are university funds that are sponsoring the person. Even if those funds came from a federal grant, they do not make the person subject based on funding, because it was not US government funding directly given to the exchange visitor like Fulbright, for example, right? So A lot of those programs that are sponsored by state agencies are not subject to the 2-year rule. And then the third condition is if the person comes in the US to do something that is on the skills list for the country that they came from. And the Department of State publishes a skill list that was just updated in December of 2024, and actually was a good update because it removed a lot of countries from the skills list. So a lot of folks are no longer subject under the skills list, like India and Brazil and different places. But for those folks who are subject, then we have to do J1 waivers, which are not easy to get a lot of times, especially for physicians, which is what we do most of the time. But there are pathways to keep the person here and change their status to H-1B or something else. But there's extra hoops to jump through because of the 2-year home residency requirement.
Right. So that, I think, a good reminder then for folks to figure out if they do have workers on a J1, start early that process of figuring
At
out,
least a
are
year
they
out.
at least a year out, right? And start working from there on. Are they, do they fall within that 2-year requirement? And if not, what is the next step, right? How do we keep them on an H-1B? What about workers, and this is something that I know some folks have been thinking about, is say they have a worker on humanitarian parole. So maybe they came under the Uniting for Ukraine program and they want to retain them and they're already here in the US. Could they apply for a EB3, which is a permanent employment visa, or not permanent, but leading to immigration status, or an
Right.
H-1B? Could they apply for those visas while those workers are still here as a way to retain them and provide them a little bit of solid status, let's say?
Yes, very good question. And if I may broaden that a little bit, let's include DACA as well, because DACA, in a lot of ways, walks and talks to like the parole programs, right? So DACA and these parole programs, just to sort of give a very brief overview of what they are. So DACA and these parole programs are temporary programs that provide folks who are otherwise don't have like letter status, is what I call it, like H-1B or F-1 or whatever, who otherwise lack status, give them the opportunity to remain in the United States for a period of time and to be employed during that period of time. So the parole program itself gives the person the ability to stay in the US, and based on that parole, they can apply for an employment authorization document that gives them the ability to work in the US. So there's separate benefits, if you will. DACA the same way. You have DACA that allows you to stay in the US, but also you have to apply for a work permit that allows you to be employed in the United States. So these are one of those like president made, president can take it away kind of programs, right? Less than statutory. So very easy to change and very easy to go away. And so one of the conversations that we've been having with our clients over the last few months is how do we get these folks into something more permanent? Exactly your question, Leo, right? Because I mean, there hasn't been any sort of signaling that DACA is going to go away, but the first Trump administration tried to take it away, so we have to assume that they're going to try again. So how do we get these folks into something more permanent? And what you mentioned in your question is actually part of the answer. Either try to get them into some sort of non-immigrant visa, which we can obtain fairly quickly. So for example, nurses that are here on DACA can get TN visas. Nurses from Mexico and Canada, that is, can get TN visas. Other professional positions that require bachelor's degrees or higher, we can get H-1B visas for. But there are other types of workers that don't qualify for TNs and H-1Bs for jobs that require less than a bachelor's degree, for example, or not in the nursing field. Then for those, employers can petition for employment-based immigration, like the EB2, EB3 that we were talking about earlier. And that process takes a little bit of time. EB2 and EB3 could take 2 to 3 years to complete. However, it's a good idea to start investing in that now. This is not something that you can react to. This is not something that you can fix if DACA goes away or if there's an announcement that it's going to go away. It's something that has to be done proactively to work on that now so that to put the worker on a path to permanent residence and get into something more permanent so that if it does go away, they're safe, right? Same thing for parolees, same sort of situation. Or some parolees actually are eligible for asylum as well. And asylum is a bit more safe than parole because parole can be taken away at a stroke of a pen. whereas asylum requires due process. You have to go through proceedings and all of that for you to be denied asylum, for example. And asylum provides a separate basis to apply for a work authorization document. So there are strategies and things that we can do for a lot of employers and employees in this situation. And this is a large part of our practice. So do consult with us or somebody like us that does employment-based immigration law that can tell you like what's possible and what's not possible so that you can put a plan in place for the next 2 or 3 years to try to get those folks into something more of a sure footing.
Ask a real
Great.
101 question. And I think I saw somebody else ask it, so I don't feel so silly. But if somebody came over here without any form of authorization, but they've been living here and following the law and figuring out a way to make it work for 10, 15 years, is there a path for them to gain legal citizenship or some other authorization?
And as the typical answer from a lawyer is it depends, right? It depends on a variety of factors. But here's the big picture answer on that. So in a vacuum, just somebody who's here undocumented, entered without status, or came with a visa and overstayed, typically, by and large, not eligible to be petitioned for by an employer to obtain employment-based immigration. However, there are exceptions to that, and exceptions are fairly plentiful in that arena. And one of the more common, so the two common exceptions that we see largely in our practice are these things. First, DACA kids. If they came to the US as a child, but then obtained DACA in their teen years, so prior to turning 18 and a half years old, and kept DACA going, then there is a path forward. They will still be required at the end of the process to leave and go at the consulate to apply for a visa, but that's like a 2-week trip. We do all the paperwork in the US, they leave for a couple of weeks, pick up their visa and come back to the US as a permanent resident. So that's a very common scenario. The other common scenario is folks that have either a spouse or parent who is a permanent resident or US citizen, typically parents, through which they can apply for a waiver. So even if they have these status issues or whatever, an employer can still petition for them, and then the employee has to apply for this extra waiver, extra paperwork that they have to do, but they can still complete the process. Unfortunately, this is one of those hard to screen on your own type of situations and will require an attorney to sort of like look at the factors because it's highly dependent on the personal circumstances of the worker, right? When did they come to the US? How long were they here without status, with status? Do they have family members that qualify for this waiver? That kind of thing. But it is doable. So general rule, not much you can do about it, but quite a bit of exception.
Thank you. And want to flag it. We're talking about this obviously from a workforce lens and employment lens, but there are also family-based pathways for some folks. So it's good to have a conversation of with an immigration attorney that can look at all the options and all the different beyond just the employment-based ones.
Yeah. And may I mention something of best practice here, Leo, because the audience is largely employers, right?
Yeah.
If you're going to reach out to me because you want to help certain workers that may or may not be documented, it is best if the workers come to us directly and you don't engage us or somebody like us, like a firm directly. Because if you, as an employer, engage us to help your workers and we discover that they are not documented, that knowledge is imputed to you and it can hurt you in an I-9 audit, right? But if the worker comes to us directly and we say, your employer can't help you, period, without even knowing who the employer is, doesn't matter who the employer is, right? Because we screen them personally, can you finish the process? Then you don't have any knowledge, either actual or imputed or constructive knowledge. And so you sort of like insulate yourself from any sort of like I-9 liability. So you can still choose to pay for the consultation fees and whatnot, whatever, but it's best if you say, go talk to this lawyer, if you have questions. I don't want to know anything about it, right? Don't ask, don't tell, because you don't want somebody inadvertently who has a proper I-9 in the eyes of the law to give you actual knowledge because it creates problems for you in an I-9 audit.
Thank you. Yeah, that's very important and goes back to your point earlier with I-9. So you want to have the same consistent. Yeah, I think John, in the comments, that was right, your question. And it's important to be consistent across the board
Yes.
with those kinds of policies, right? You don't want to sort of start guessing or identifying individuals. I'm going to ask you, and I want to give you a couple minutes to kind of share any closing thoughts and then pass it back to the secretary for the same. But just to see some questions on various different employment authorization documents. And one challenge that I know for a lot of employers is that sometimes, individuals on, say, humanitarian parole have 12 months of employment authorization. They apply for renewal, and the guidance from the federal government is write on the notice, valid for, X number of additional days while that is processed. And that can look, very suspicious if you just come to someone and say, I wrote that the government says that this is still valid, and here it says expired.
Yeah.
Can you talk a little bit about sort of with those kinds of employment authorization documents? Is there something employers can look at or some broad guidance for them?
Yeah. USCIS has a lot of good guidance and materials on their website when it comes to I-9s. They've actually come a very long way in how helpful they've become in sort of like giving employers the knowledge or the information on how to process a particular document with an I-9 in the I-9 context, right? So a lot of times a little Googling in the little searching in the USCIS website can provide a lot of the answers to the questions, because it'll say, like, for example, when there's an extension application pending, then this is still authorized, and this is how you do the I-9. You notate this, you put this, you add this note, you cross this, and then you're done, right? And so if you, with a little bit of searching, that you would be able to answer, I'd say, about 80% of your I-9 questions that are out of the ordinary. We're not talking about like U.S. citizens showing up with a U.S. passport, right? We're talking about these fringe cases. In the rare example where it's like way too complicated, or you can't find the answer and the employee says, no, this can still be done, then you may have to call me or somebody like me, and we'll look into it and we'll be able to tell you exactly how to do that. It's not necessary. Like, I have clients that, reach out to us obviously for these questions, of course, but a lot of these are easily answerable on your own. But there are some that are pretty thorny, in which case we can provide guidance for something like that fairly quickly and inexpensively.
Great, thank you. So I know we have a ton of questions that I'd love to be able to get to. And like I said, we'll send out this video. We'll share some resources on I-9 and a couple other things, and provide some context for folks if they have follow-ups. But thank you so much,
Yeah.
Olsi, for taking the time. Yeah, please.
I don't know if this how you guys want to do this or not, but I'd be glad if you want to share my contact information as well. I'd be glad to make it available. If folks have questions, follow-up questions and whatnot, there's 400 people on this call. So if I get 400 questions, I will not be able to answer them all right away, but I will eventually get to them. And if I get questions from employers all the time because of referrals and whatnot, and if it's something I can answer quickly, I do. If it's something that requires a longer conversation or retaining us to provide advice or whatever, I'll let you know that, hey, you're going to have to hire us or somebody like us to take care of that. But I'd be glad to act as a resource to folks, because I know there's a lot of questions that like 63 questions that we haven't been able, I'm sure we haven't been able to get to a majority of them. So
Yeah, we appreciate it. And I'll pass it to Secretary if you want to give some closing thoughts. Thank you.
Sure, thank you. Thank you so much, Olsi, and thank you, Leo, for organizing this. Like I said, I learn so much every time I hear about immigration. My parents were immigrants. I was born in the US and I still don't know anything about it. And I've come to think of US immigration policy kind of like one of those old New Mexico houses where, they started with a house that kind of made sense, and then you built on a room and you converted a garage, and there's the room where the ceiling is 4 feet tall and there's 3 outbuildings. And at this point, it's just too complicated to figure out how to build a brand new house that can actually accommodate everyone, and especially be navigable by businesses. So to everybody who wrote in the chat, this is confusing, I'm with you. And I think everybody finds it confusing. So what I think we can do is we can aggregate these questions, kind of draft some answers that are generic enough to be acceptable. And we can run them by you, Olsi, and that way you don't have to field 400 emails, but we'll also make your contact information available too. But just for folks, and we'll also, when we post this, we'll kind of put those FAQs and put some links to websites that, like the USCIS, that you might want to go look at for official information. I think we also probably need to do at least a special document, maybe a special webinar just on I-9 audits, because I saw all your questions there, and some of them were really detailed. And I know, you know, the last time around we did some field work, and we did some in-community seminars about I-9 audits, and we're looking at that as well. So to everybody here, thank you so much for joining us, and we would really love to see you at our future webinars. I think our next one is on the Healthy Workplaces Act, paid sick leave. So for all you employers out there or employees who have questions about this still relatively new law, keep an eye out for that. And again, just thank you all so much for being here, and thank you, Olsi and Leo.